Warning: you are responsible for learning all content from cover to cover within your book. You have all the tools and resources you need. Now go and win. Chapter 7: Medical Legal Aspects of Out-of-Hospital Care. As a paramedic, you must be familiar with the legal issues likely to be encountered in the field. Laws vary from state to state, and protocols can vary from county to city to city. Always rely on your attorney's advice whenever you are faced with a legal question. When we operate our job day to day, there are inherent risks that we partake in, and we've already discussed the risk to ourselves physically, emotionally, and mentally. However, let's talk about some of the liabilities that we face legally. This is a huge aspect of the job that you have to be competent with, because if you don't understand the risk that you are getting yourself into, then you could potentially do something dangerous to your career and lose your license, lose your ability to put bread on the table. All right. As a paramedic, you have specific legal responsibilities to your patient, crew, medical director, and the public. These duties are largely based on generally accepted standards and are often set by statutes and regulations. And as we've discussed before, we do have ethics. Ethics are common principles that we share, not necessarily morals, but they are common principles that we share as professionals. And we also have something that is very similar to ethics called standard of care, and we will talk about that today. All right. If you do not perform your job appropriately, obviously it may result in a civil or criminal liability, which could ultimately end your career. And your best protection from liability is to always perform a systematic patient assessment, provide the appropriate medical care, and maintain accurate and complete documentation of all incidents. All right, here's a sweet picture of a dude that's probably totally not an actor. It's not a staged picture. This is live action coming at you. But again, in situations like this in real life, whenever you do have a patient who is combative, you have to be careful. I know we've all been there by this point in your education, but you do have to be very careful with what is said, what is documented, what is treated, because ultimately somebody probably is watching, for one, and for two, you still have to treat this patient with the utmost care. You still have to be just, and you still have to be non-biased. So let's talk about some ethical responsibilities that, we're still talking about ethical responsibilities, obviously. But one of the biggest responsibilities that you have, and this goes into your duty to act, and I know that's a term that you remember from EMT school, but you must respond promptly to both the physical and emotional needs of every patient. So anytime 911 is activated, you're on shift, there's that duty to act. Treat all patients and their families with courtesy and respect. Again, you are non-biased, non-judgmental. Maintaining a mastery of your skills and medical knowledge. So this is what this is talking about, is just staying competent. Actually train on the job that you do 90% of the time. Participate in continuing education programs, seminars, and refresher training. So this is how you stay current. This is how you stay up to date. Critically review your performance and constantly seek improvement. So there should be programs put into place at your service, such as QI, QA, quality improvement, quality assurance, continuous quality assurance. These programs assist you in getting better. Report honestly and with respect for patient confidentiality. So obviously, whenever you are transferring care, whenever you are documenting things appropriately, report honestly. So when we talk about honesty and integrity, we're also talking about objectivity. For the most part, the only thing that is subjective that needs to be in your patient transfer or documentation at all would be what the patient has told you. Your opinions and the subjective thoughts in your mind about the patient's situation should never leave your mind. So also, work cooperatively with and respect other emergency professionals. This is a dichotomy that you will face as you work mutual aid. You work with other medics of similar experience. You're going to have to be able to use emotional intelligence and know how to lead people. Okay, so let's talk about how ethics technically are not laws. Again, these are just principles that a particular group or community of professionals share. And morality. So again, morals may change from person to person. However, ethics are shared by a group. Principle of right and wrong as governed by individual conscience is morality. So ethics is a group, morals are individuals. And as we discussed in the ethics chapter, morals cannot be dictated by ethics cannot be dictated by one religion or belief alone. Because we have differing people of different nationalities, different cultures, different beliefs. So, all right, let's talk about the legal system. So we have 4 primary sources of law, and we'll talk about those right now. Constitutional law. It's based on the Constitution of the United States. Common law, which is case or judge-made. The common law is also referred to as case law, and it's based on society's acceptance of customs and norms over a period of time. Statutory law, which is also known as legislative. It's created by lawmaking or legislative bodies, and it takes precedence over common law decisions. And then finally, we have regulatory law. This is also known as administrative law. It's enacted by an administrative or governmental agency at either the federal or the state level. Okay, so those are the sources of law. Let's talk about the categories of law, and this is pretty important to understand. Criminal law. So criminal law deals with the crime and punishment portions of the law. Prosecution on behalf of society for violating laws is meant to protect society. And as we move down, we'll talk about civil law. Civil law deals with the non-criminal issues. So if the plaintiff seeks to recover damages from a defendant, that is typically what we see whenever we're brought to court by either a family member of a deceased patient or the patient themselves. If you are brought to court either as a witness or as the primary caregiver, then this is typically what's happened. So civil law is branched into tort law, but we'll talk about a tort in a minute. Again, civil law is typically whenever a plaintiff is seeking to recover damages from the defendant. The defendant will be you. The defendant will be your EMS service. The plaintiff will be the patient or their family members. So these are non-criminal issues, typically personal injury, contract disputes, or matrimonial issues. So let's talk about that a little further. Tort law deals with wrongdoings, so civil wrongdoings or wrongs committed by one individual against another. All a tort is wrongdoing. That's what I want you to think about whenever you think about the word tort. So it is a wrongdoing. It is why the person, the plaintiff, is suing the defendant. So they feel like they were treated inappropriately. They weren't treated fast enough. The provider breached the duty to act, or can be held liable. So trial courts. Also, a tort law includes negligence, medical malpractice, assault, battery, and slander. And those are things that we're going to talk about and dissect a little further, because those are the most common things that we are brought to jury for. So negligence, medical malpractice, medical malpractice, assault, battery, and slander. And we can also add libel. All right, and we will talk about each of these individually as we move on further. So trial courts, those involve judge and or jury that that will determine outcomes of individual cases. And then you have appellate courts that they hear the appeals of decisions by trial or by appeals courts. So let's talk about a civil lawsuit, what happens, and kind of we'll talk about the anatomy of it, if you will. This will be what constitutes a civil lawsuit and what happens. So you have the initial incident. That's the actual starting point of the injury. You have an investigation. That's an inquiry into the facts and circumstances surrounding the incident to determine whether the case has merit. So this is where you will have discussions with witnesses, discussions with people on scene, bystanders, so on and so forth. Filing of the complaint. So the plaintiff files a complaint with the court commencing beginning of the lawsuit. And then the defendant is served with a copy of the complaint. Or, they are handed a piece of paper and they're said, hey, you're being sued. Typically this is going to go to the department, and then answering the complaint. This is the defendant's attorney will filing an answer with the court, which will address each allegation. All right. And then we have discovery. So the discovery is all the relevant information about the incident, and it's being shared with both parties. So this is supposed to be super objective. So pretty much it's saying, this is what happened. Both of you take a look at it, and then we will meet at a later date and discuss it in front of a judge and jury. So the the examination happens before trial, and then we have, which is the disposition. Or the deposition. Deposition. This is where witnesses answer questions under oath. So again, this is supposed to be completely objective, completely honest. And then you have the interrogatory piece. This is where written questions will require written responses. Okay, and then there are also requests for document production that occur in this situation. These are requests from both sides for relevant documents. Okay, so then we move on to the trial. So each side is given an opportunity to present evidence and testimony. So these are where the witnesses and the bystanders on scene will come into play. A decision will be reached by either a judge or a jury or a combination thereof of either guilty or not guilty. So the guilt or the liability and the amount of damages to be rewarded will be decided in here, or appeal. So this is what happens afterwards, after the decision. The appeal of the decision typically is limited to errors of law made by the court, and then there's going to be a settlement. Maybe there may or may not be a settlement. This is an offer of money that is less than what the defendant is being sued for. It typically can occur any time during the lawsuit, just to stop the lawsuit from continuing on further, wasting more time, wasting more money. Lawsuits are incredibly expensive, but the settlement typically is, so if the defendant is being sued for $1 million and they say, you know what, this is crazy, will you settle for $850,000. We'll end it today. We'll move on. Everybody moves on with their life. So that is what a settlement is. So let's discuss those components that we were talking about in the previous slides whenever we were referencing the components of tort, or the different types of tort. So in order for any type of civil trial or any type of prosecution to prove negligence, you have to have 4 major components, and this is very important. You will get registry questions that are tailored toward this competency. You will get questions on my test that are tailored towards this competency. So you definitely need to know this. In order to prove negligence done by a provider, you have to prove that there was a duty to act. You have to prove that there was a breach of that duty to act, and we'll talk about that here in a little bit. You must prove that there was a proximate cause, or that a damage occurred, and those damages were caused by the breach of the duty to act. So those are the 4 major components. The paramedic had a duty to act. The paramedic breached that duty to act in some way. There were damages caused to the patient or the complainant, and there is a proximate cause. There is a cause that can be proven to be the cause of the damages done by the paramedic. All right. So as we move on down, medical malpractice, it is what it sounds like. We'll dissect that a little further here shortly, but it is primarily the inappropriate use of medical knowledge, medical treatment, or the lack of use of treatment causing proximate cause. Assault, that is a verbal threat, that is verbal damage done to the patient. So if you look at a patient who is being non-cooperative and you say, if you don't calm down right now, I'm going to start a 14 gauge IV on you, that is assault. Battery, that is physical damages or wrongdoings done to the patient. So literally, if a patient looks at you and says, hey, I don't want you to touch me, I don't want you to take my blood pressure, do not take my blood pressure. And you say, well, I have to get vital signs anyway. You grab the patient's arm and force them into taking a blood pressure. You have literally just committed battery. Slander. Slander is the spoken defamation of character. So if you transfer a patient over and you walk over and you say, yep, this chick's, she's probably got some type of venereal disease. I think she's a little loosey-goosey, blah, 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 blah. If you say something along those lines, you have committed slander. Libel, if you write it down. If you write down exactly what I just said, share it on Facebook. I ran a patient today, her name is such and such, and I'm pretty sure she sleeps around and she caused her own problems. That is written defamation of character. So as we move forward, it's very important for you to know the basic principles of all of these different elements of tort. So again, tort is nothing more than wrongdoing. You have negligence. Negligence must be proven in order to win a lawsuit. You have 4 major components of negligence: a duty to act by the paramedic, a breach of that duty to act, damages that occurred to the plaintiff, and then approximate cause, proving that the paramedic caused the damages. Medical malpractice is the lack of or the inappropriate use of medical treatment. Assault is verbal wrongdoing to a patient. Battery is physical wrongdoing to a patient. Slander is spoken and verbal defamation of character. Libel is written defamation of character. Okay, so we'll move on. So let's talk about laws that affect EMS and the paramedic. We'll start off talking about scope of practice, and we know that each level of pre-hospital clinician carries its own scope of practice, these are nationally set standards and nationally set standards of care that each paramedic throughout the country should be operating at. So your scope of practice is a range of duties and skills that paramedics are allowed and expected to perform, set by state law or regulation and or by local medical direction. So the circumstances in which an order for medical direction may be legitimately refused include whenever you are ordered to provide treatment that is beyond your scope of training or your scope of practice, and that's inconsistent with established protocols or procedures, and whenever you are ordered to administer a treatment that you reasonably believe would be harmful to the patient. So we've kind of spoken about this conversation in previous lectures when we talked about, you have to be able to tell a physician, this is what you just ordered, are you sure? Let me repeat it back to you. You repeat it back to them. If they say, yeah, go ahead with it. I said atropine. I don't mean adenosine. Okay. Well, doc, I really don't know if I should be doing that because atropine is going to do this to the heart instead of this. Oh, yeah, you're right. So, anyhow, so scope of practice is something to be very, very familiar with. And the issue that you need to think about is you not only know your scope of practice but like the back of your hand, you should know your partner's scope of practice and everybody else on the scene. You should know, as a paramedic, you should know the advanced EMT scope of practice and what those people are allowed to do, because if you hand them a vial of epi 1 to 10,000, 1 milligram, and say push it, you have literally broken their scope of practice. So certification, We've talked about the differences between certification, licensure, and registration and reciprocity. So certification is a recognition that an individual has met the minimal qualifications. A licensure is the reward for that. After you have certified that they graduated a program, and now they are licensed to operate. And they are put into a registry, which is a list of licensed personnel. So understand EMS laws and regulations within your state like the back of your hand, because if you don't, you are setting yourself up for failure. So let's talk about some motor vehicle laws. These will vary from state to state. But special vehicle laws govern the operation of emergency vehicles and equipment, and they're widely accepted, such as the stopping at intersections, the use of emergency lights and sirens. But they usually apply to vehicle maintenance and the use of sirens and stopping at intersections. Many states and jurisdictions have enacted laws and ordinances governing the use of phones, tablets, and GPS devices, which may or may not apply whenever you are operating an emergency vehicle. So that is something to consider whenever you are driving emergency and you have to you have to use a GPS. Well, first off, 90% of the time that situation can be prevented by just knowing your first in territory. Yes, it is very, very hard to sit down with a map book, draw it over and over and over and over, memorize the list of streets that come off of the main arteries of the road in your territory, but that's your responsibility, because if your battery dies on your phone, GPS, you don't have a mobile mounted GPS, or the CAD is down and you can't use that, you have to be able to fall back on something. So know your territory. So also we'll move on to talking about things that you are required to report. So let's separate these a little bit just to make it a little more required to report the following. So each state has different laws that protect the public, and it's your responsibility as a paramedic in order to report these specific things. So suspected spousal abuse, child abuse, abuse of the elderly, violent crimes, animal bites, and communicable diseases. Also gunshots and stab wounds. Any of these type of things, you are required to report them. And even if you report them and you tell PD on scene or SO on scene that you want this to be formally reported, you have to document it in your narrative as well. Now, you cannot accuse someone of abusing their grandmother within your report. However, you can describe the bruises on her arms where there shouldn't be bruises that are concurrent with the type of injury that would be. If you describe those bruises, if you describe the type of pain, and you describe the affect that she has with the person who potentially abused them, withdrawing from the person, not making eye contact with the person, doing whatever they say, being fearful of them, not talking when they're in the room. That's, if you could describe those type of actions and behaviors within your objective narrative, and then you describe the injuries that are concurrent with it, you're not making any accusations. You're just documenting what you see. However, if you say, I believe that such and the son of the patient has been abusing patient, you've literally just made an accusation which can be considered libel. So, again, sexual assault, same thing. Describe the environment, describe what you see, report what was said. Gunshots and stab wounds. One big thing that I want to talk about before we move further in gunshots, you do not have the training or the technology in order to determine what is an entrance wound and what is an exit wound. Now, typically, depending on the caliber, you can use some common sense and figure that out, but the smaller the caliber, the more difficult that is to determine. And it also depends on the range from the patient. So we'll talk about ballistics later on in your course. Well, Dr. Creel actually has a very nice lecture on ballistics that he'll come in and do for you guys. So just be very careful in documenting exit and entry wounds. Strictly document penetrating wounds, and then give the approximation of their size in millimeters, or of their diameter in millimeters. I have a 3 millimeter penetrating wound to the suprapubic region of the abdomen. I also have a corresponding 4 millimeter penetrating wound on the posterior aspect retroperitoneal. So, you just use your medical terminology to describe injuries. Do not, just like you're not accusing somebody of abuse, you are not trying to diagnose what is entry and exit. Because a good lawyer, in a situation where you are called to court, they will call that out in a heartbeat. They will say, in your curriculum, are you trained and skilled on the different burn patterns of microscopic borders in entry and exit wounds? Well, no, I'm not. Okay, then how is this valid? How is this, this accusation that this is an entrance wound valid? And then they'll start dissecting more into your report, and they will rip you into pieces and make you look incredibly incompetent. So, moving on. So let's talk about some laws that are put into place to protect paramedics from legal liability. So whenever we talk about immunity, I want to define immunity a little bit. Immunity is nothing more. It is exemption from legal liability. It's a judicial doctrine that prohibits a person from bringing a lawsuit against a government without its consent, and it does not generally protect individual paramedics. So, again, if you do something that's grossly inappropriate or grossly incompetent, then you may be on your own in that situation. But there is. There are a few things that you are not immune of. So, and typically that is what can cause proximate cause, or what contributes to proximate cause in reference to negligence. So there is a criminal punishment set in place for the acts of assault or the acts of battery against a paramedic while he or she is providing medical care. If you verbally threaten somebody, you can be taken to court and tried and found guilty of assault or battery. Also, if there is an obstruction of paramedic activity, either in place by the paramedic themselves, so if you breach your duty to act and you just say, I'm not going to do anything, or if somebody gets in the way of obstructing, then that is one way of protecting yourself, but you must document it. If you do not document those type of things, let's say if somebody's going into cardiac arrest, or let's say that there's some gang violence. This is legit. This has actually happened. Gang violence in a major metro area. Somebody shoots an individual. You get on scene, and the people who assaulted and shot that individual are preventing you from providing care because they want that individual to die. So that is obstructive or obstruction with, paramedic activity. So we'll talk about Good Samaritan laws as well. That a Good Samaritan law provides immunity to people who assist at the scene of a medical emergency. Laws of many states have been expanded to protect both the paid and the volunteer pre-hospital personnel. Also, if you are just an off-shift paramedic, or if you're just a regular Joe Schmo and you start providing compressions to somebody who just went into cardiac arrest, or somebody that you think went into cardiac arrest, and you're not on shift, you are protected by the Good Samaritan law. The use of physical restraints is typically that's a very heated subject, and you have to be very careful and know your local protocols, know your local restrictions in reference to what your medical director approves. If you have hard restraints, if you have leather restraints that that buckle a patient down to a stretcher, and you are allowed to use them, make sure that you are trained and make sure that they are used appropriately. You may only be allowed to use soft restraints, which are restraints that are typically made by very thin webbing, but are easily cut away in the situation where, the patient goes into cardiac arrest, or you need to be able to move and treat the patient in a different manner. The Ryan White Care Act, it is in place for protection of the paramedic in the event of exposure to bloodborne or airborne pathogens. And this act allows access to medical records to determine whether the patient has tested positive for an infectious disease. So if a patient has tuberculosis, they know about it, but they withheld that information from the paramedic, coughed all over the paramedic, and the paramedic now has TB. So since that portion of medical history was knowingly withheld from the paramedic, then the paramedic at that point can actually sue the patient. Okay. So we are required to provide a level of care to patients consistent with education and training, and is also equal to other paramedics with equivalent training. This definition defines to a T standard of care. So let's put that here. Standard of care is defined as the requirement of a paramedic to provide a level of care to patients consistent with education and training equal to other paramedics with equivalent training. Okay, and that's one thing that will be evaluated by experts. If you are brought to court, they will hire in people who they considered expert witnesses or experts in certain industries to review your documentation. They'll review the treatments, they'll review the patient outcome, and then they will determine, yes, standard of care was upheld for this patient. The paramedic is not liable for what happened. You cannot tie proximate cause of the damages to the paramedic because they acted appropriately and provided an adequate standard of care. However, in several cases, there may not be that fallback. If you don't do your job or if you're not competent, you're setting yourself up to not perform to the standard of care expected by other paramedics. So you are expected to perform duties in a reasonable and prudent manner. And when we talk about that, we're talking about how you absolutely must expeditiously, you must quickly treat these patients. You can't just do it at your leisure, at your time. If you're tired, you still have to perform the same care fully. You can't just cut corners and just do certain things because you feel like it or you're too tired. Whatever's going on in your life in that moment does not matter whenever you are answering the call to duty. So also, if you have an intentional tort or an intentional wrongdoing, it's a civil wrongdoing committed by one person against another based on willful act. So again, let's talk about the patient who is being combated for whatever reason. Let's say they're having an anxiety attack, or they're overdosed on medications, or if they are having a psychiatric episode, and you say, if you don't calm down right now, I'm going to start bilateral 14 gauge IVs on you and it's going to hurt really bad. Or if you don't stop faking that seizure, I'm going to start an IV on you. I'm going to hit you with a needle or poke you with a needle. So you just committed assault. And then if you actually do that, if there was no need for a large bore IV, literally none, the patient was stable, you're not going to administer medications, there is no justifiable reason to have a 14 gauge IV in that patient, and then you put one in there, that can be construed as battery. So, and you did it on purpose. You were willingly committing those acts against the patient. So that is an intentional tort. You did a wrongdoing on purpose. Negligence and medical liability. So, like we talked about earlier, there are different components that comprise negligence. Negligence is a deviation from accepted standards of care recognized by law for the protection of others against the unreasonable risk of harm. So that is the textbook definition. However, you must have those four basic components we addressed earlier to prove negligence. In healthcare professions, negligence is synonymous with malpractice. So if you talk about situations where malpractice is done in patient care pre-hospital, this is where it is spread out. So a lot of times, people, whenever they worry, when we're sitting here and I'm telling you about negligence, you're probably worried about pushing the wrong drug, medical errors or medical, any type of mistake. You have good intentions, you're treating the patient with respect, but you screw up and you give the wrong amount of a drug, or you give the wrong drug. That is so rare whenever we talk about what causes torts, what causes the wrongdoings that prove negligence. 45% of the time, patient handling is what causes the tort. So dropping patients, dropping stretchers, worsening the patient's condition by moving them. Emergency vehicle movement or collisions, 31% of the time. So if you were flying down the road, lights and sirens, and you busted the intersection without stopping, and you get into an accident that damages the patient even worse, well, at that point, you've breached due regard, which breaches your duty to act, which causes negligence, and you fall under negligence. Medical management. So this is where we're talking about medication errors and things of that nature. 11%. So that's a pretty big difference between 45% down to 11%. EMS response or transport. So that in particular, we're not talking about collisions. We are talking about the times. How long did it take for you to get en route? Did you drag your feet? Did you lie about where you were coming from? Were you really at the burger shop getting a milkshake and chilling whenever you were supposed to be at the station, and you told dispatch, well, we are responding from the station, emergency, and it takes you 3 or 4 extra minutes to get there. So if they can prove that those 3 or 4 extra minutes were crucial in the patient's care, or if you did not transport emergency, but you should have, vice versa. Also, equipment failures or lack of equipment. So why can you be in trouble for a lack of equipment or equipment failure? Well, if you didn't check your truck off that morning and you didn't realize that you were out of adenosine, or you were out of cardizem, you were out of whatever drug, or let's say that you were out of IV supplies, or you were out of saline. If that falls back onto you and it was preventable, you just were too lazy and you didn't do your job appropriately, then yes, you can be held negligent. But that's only 4% of the time. So that's encouraging. And then other causes, around 9%. So let's talk about duty to act. So duty to act is the formal, contractual, or informal legal obligation to provide care. If you are scheduled to be on shift on Monday at 8 o'clock, you show up at 7:30, you're clocked in, you get on the truck, you get the keys from the other paramedic, you have a duty to act until you say, I'm going home, I'm not on duty anymore. Your duty to act. So you have a duty to respond to the scene and render care to ill or injured patients. You have a duty to obey federal, state, and local laws and regulations. You have a duty to operate emergency vehicles reasonably and prudently. And you also have the duty to provide care and transportation consistent with the paramedic's scope of practice, local medical protocols, and the standard of care for your scope of practice. And you also have a duty to continue care and transportation to an appropriate facility. So, as long as you follow these basic principles, you should be fine. I mean, as long as you initiate all of these duties, you're not breaching anything. So when we talk about breach of duty, let's talk about a few different types of breach of duty to act. You have malfeasance, which is a performance of a wrongful or unlawful act. You have misfeasance, which is the performance of a legal act in a manner that's harmful or causes injury to the patient. Or you have nonfeasance, which is a failure to perform a required act or duty. So that is when you know that a particular act or intervention must be done and you don't do it. So it's a failure to perform a required act or duty. Res ipsa loquitur. So these are the damages that would not have occurred in the absence of the negligence. So in a shorter definition, something that may be easier to understand, this is the proof that the damages were caused by you. or caused by the thing that you didn't do. So the complainant must prove that damages would not have occurred in absence of somebody's negligence, your negligence as the paramedic. The instruments causing the damages were under the defendant's control at all times. So either you didn't do the right thing and you knew that you were supposed to, or you were incompetent and you didn't know your protocols, or you knew that you were doing the wrong thing. Either way, you fall at foot here. The patient did nothing to contribute to his or her own injury. So the injury that was worsened or that was caused by the paramedic's negligence, the patient had nothing to do with it. The patient did not wreck the ambulance. The patient did not distract the driver in order to wreck the ambulance. So negligence per se. So negligence per se can also be, you think about automatic negligence. So it's a violation of a statute that results in injury. Actual damages. So these are the damages to the patient or other individuals that are harmed in a way that can be compensated by the award of damages. It's the essential component of the lawsuit. Without the proof of the actual ill effect, the lawsuit cannot be won. All right. And then the plaintiff may seek punitive damages as well. The plaintiff may say, I want that paramedic's license to be pulled. I want $1 million, and I don't want them to ever work again. They need to go bag groceries for the rest of their life. Proximate cause. So this is the action or inaction of the paramedic or ending up in affecting the patient in a negative way. So the inaction or the action of the paramedic that caused or worsened the damages suffered by the plaintiff. So the plaintiff has to actually prove this. There has to be proof without a shadow of a doubt that the paramedic is liable here. All right, so let's talk about how we defend ourselves against charges of negligence. Well, first off, I'm just going to add something in here. Good documentation. You must document appropriately. You must protect yourself in the ways of documentation. So Good Samaritan laws are one thing that can help. They can assist in protecting the paramedic. However, if the paramedic, if they did not provide care appropriately, or if they provided inappropriate care, then the Good Samaritan law really can't protect them at that point. You do have, seldomly, you'll have governmental immunity. Statutes of limitations typically is between 2 to 5 years. So what statute of limitation is it can be considered the amount of time that somebody has from the point of injury until the point of lawsuit. So let's say that if you dropped a patient, broke their hip, and they ended up having a surgery, that patient has 2 years to sue you for that. And that can change from state to state. Some states may say, well, you know what? You have 5 years for statute of limitations. So 4 years and 6 months down the road, if that patient says, you know what? I've lost my job. I can't pay for anything now because I had a broken hip and I'm paying this surgery. I'm going to sue that paramedic and that service that dropped me. They can still do it as long as that statute of limitations is intact. All right. Contributory or comparative negligence. So again, this is what will prove that the paramedic is not who caused the negligence, that the patient was actually negligent and caused the injury themselves. So obviously, things that we can protect ourselves from medical liability is appropriate education, training, and Con Ed, appropriate medical direction, accurate and thorough documentation. I'm telling you, this, as long as your report is sound, you can defend yourself adequately. Professional attitude and demeanor, also a very good reputation. If you have very good character witnesses that will support you in that moment. Acting in good faith, using common sense, and also having adequate medical liability insurance. All right, so let's talk about some special concerns in reference to liability. So medical direction. A medical director, they may be liable to the patient for negligent supervision. So if the protocols are out of date and the paramedic says, look, I was performing what my protocols told me to do. It may be kind of dumb. You may say, well, you should know that it's updated and you should have called for orders to breach your protocols. However, in that moment, the paramedic's not wrong. If that is their medical director's supervision, then they can only do what they can do. All right, so the borrowed servant doctrine. Depending on the degree of supervision and the amount of control the paramedic has over the emergency care providers, the paramedic may be liable for any negligent act committed by these providers. So this is what I was saying. You must be competent with the scope of practice of the people that are on scene. Also, if somebody runs up to you and says, hey, I'm a nurse, give me a set of IVs, I'll start an IV on the patient, and you're in the middle of the road, it's probably not the smartest thing to do unless you can vet that person. So know the scope of practice and the standard of care expected for the people that are on scene with you, and make sure that it's being enacted. Civil rights. Patients may sue for violating civil rights and being discriminatory. Either age, sex, gender, sexual orientation, race, it doesn't matter. If they can prove that you discriminated against them, you didn't provide adequate care, or if you caused battery or assault due to a discriminatory reason, then that's a special liability concern. The off-duty medic. So most of the time, the Good Samaritan law will protect you in this situation. However, if you knowingly commit a wrongful act, then at that point they can prove if you were educated appropriately, you have a paramedic level of education, you're certified, you're licensed, you're in National Registry, you should have known not to push the inappropriate drug. So you kind of fall under similar laws in that situation. All right. Airway issues. So failure to secure an airway or failure to recognize airway compromise can result in devastating or fatal injuries for the patient. Now, numerous lawsuits and settlements that have been filed related to airway management, especially failure to recognize that an ET tube has been improperly placed. So if you are in the epigastric area with the tube, you inflate it and you bag and bag and bag and bag and bag. SATs continue to drop, end tidal continues to increase. You get them to the hospital, transfer care, patient goes into cardiac arrest, and they die. You are liable for that patient's death. So again, as we talked about before, restraint issues. Be careful with how you restrain patients, and make sure that it's appropriate. Do not use your body to restrain patients. So the patient who must be physically or chemically restrained due to the patient's behavior, you must have proper documentation, proper reasoning for using those restraints. And again, be very careful with how you restrain them, because several patients have died recently within the past 5 to 10 years due to restraint asphyxia, which is positional asphyxia. If you restrain a patient prone, or if you sit on a patient, then you literally could kill them, especially if they're experiencing excited delirium and they're already going into rhabdo and they have a lot of potassium and bad things floating around in their bloodstream. You could kill them. All right. Confidentiality. So this is going to be, when we're talking about the paramedic and patient relationships, confidentiality is one of the most important things. And we know that the HIPAA law, the Health Insurance Portability and Accountability Act of 1996, was enacted in order to protect patients' confidentiality. And, just don't roll your eyes when you think about this. I mean, you should really consider this to be a very important part of your job, because whenever you are a patient, when you go to the doctor, you would hope that they take it seriously as well. So, confidentiality, that is any medical or personal information about a patient, including medical history, assessment findings, and treatment, that should not be released to a third party without the expressed permission of the patient or legal guardian. Third party can even mean spouse. If the spouse's name is not on the list of exceptions, then you cannot legally share that information with a spouse. All right. The patient must consent to the release of his or her records. And the other medical care providers do have a need-to-know basis. So if you're transferring care to a doctor, a nurse, whoever, if in that moment of transfer of care, that is considered a need-to-know. However, when you go back to the station and the guys on the engine have their feet propped up and they're just chilling, watching Netflix or playing Xbox or PlayStation and playing with their belly buttons, and you come in tired after running 12 calls, and they say, well, what happened on that one? You go to that address again. What was wrong with her this time? If you explain what happened and explain the details of the call, you have literally just breached patient confidentiality. So that is not considered a need-to-know basis. If you're not transferring care, there's literally no reason for them to know. EMS is required by law to release a patient's medical records. So in the situation of any type of legality issues or transfer of care issues, then you have to transfer that information over. And there are also third-party billing requirements. So whenever you get the signatures at the end of a transport, one of the signatures is saying, I've explained to you what the HIPAA Act is, and I'm also requesting release of your records to send to your insurance company or to Medicare, so on and so forth, so that they can be billed. All right. Again, as we talked about several times with the Health Insurance Portability and Accountability Act, these are layers of protection for patients, and all EMS employees must be trained in HIPAA compliance in regards to the patient's rights and maintaining confidentiality. So defamation. We've already spoken about libel and slander, but we'll talk about it again. This is where a person makes intentional, so this can be considered an intentional tort, false communication that injures another person's reputation or good name. Libel is the act of injuring a person's character by statements in writing or mass media. So when you post such and such on social media, whatever social media platform, with malicious intent or reckless disregard. So if you're just trying to make a joke and make people laugh, get a lot of likes and shares, that's reckless disregard for false statements that damage a patient's character. Slander is the act of injuring a patient's character through spoken malicious intent. So spoken malicious intent, statement spoken with malicious intent is considered slander. Invasion of privacy. It's a release of confidential information without legal justification. So if you breach HIPAA, it is considered an invasion of privacy, and it is considered an intentional tort, an intentional wrongdoing. All right, so let's talk about consent. Consent is the granting of permission to treat. More accurately, is the granting of permission to touch. The paramedic has consent in order to take a blood pressure, start IVs, and assess the patient. By law, you must get the patient's consent before you can provide medical care. So there are different types of consent, as you remember from EMT school, and we'll talk about those here shortly. Informed consent. This is based on full disclosure of information. So also in reference to informed consent, we're not just talking about treatment and transport, we are also talking about refusals. You must make sure that the patient is informed and competent about what the risk of refusal are before getting that refusal. And then you have to document it. You have to document it appropriately, because if that patient refuses, they die after 10 minutes after you leave, you get called back out there, you're working a cardiac arrest, and you did not document in that refusal appropriately and get it signed by the patient, then at that point you are liable. That is negligence. So the nature of illness or injury, recommended treatments. So you must be able to tell the patient, hey, you fell from a 20-foot ladder. I'm going to put you on this backboard because you could have injured your spine. And if the patient says, no, do not put me on a backboard, I refuse to be put on a backboard, just document it. Okay, patient refuses to be put on a backboard, witnessed by firefighter such and such and EMT such and such. Risks, dangers, benefits of treatment. So potential side effects, like, hey, you could feel a little headache after I give you this nitro. And if they say, well, I don't want it, then don't give it to me. Well, sir, I need to give it to you. No, I don't want it. If it's going to give me a headache, I don't want it. Well, that's just a side effect. I don't care. I don't want it. You can't give it. Alternative treatment possibilities. Also, the risks, dangers, and benefits of accepting them. And also the dangers, like I said earlier, about refusals. You must appropriately document refusals. So as we talk about types of consent, we move on to expressed consent. This is the most common. The person directly grants permission for the paramedic to treat, verbally, non-verbally, and in writing. Those are all okay. Implied consent. So the patient requires emergency intervention but is mentally, physically, or emotionally unable to grant the consent. So the emotional one, that's a little that you're falling into a gray area here, because patients can claim that they were emotionally fine and that you provided care that they didn't want. However, mentally, physically, if the patient has an altered GCS, if their GCS is altered at all, 13, 14, at that point you can document that the patient was mentally unable to make sound decisions for their own care. So we operated under implied consent, started an IV, pushed D50, patient improved, blah, blah, blah. Or physically, if the patient physically cannot give implied or cannot give express consent. And you also have types of consent that are implied whenever it comes to a minor, but we'll talk about those shortly. Involuntary consent. So this is where a court orders patients to go under treatment even though they may not want it. So a lot of times this is dealt with whenever you respond to a jail. If you have if you get dispatched out to a disciplinary center or a detention center medicine, this is kind of what that falls under. Competent adult in police custody does not lose the right to make medical decisions for he or himself. Yeah. So this is when the police department calls for EMS intercept and they say, hey, we're going to take this guy to jail, but I need you to look at his leg first. If his leg is completely shattered, it's definitely broken, definitely injured, and that patient is refusing care, no, I don't want to go to the hospital. Just take me to jail. Let's just get this over with. I don't want to go to the hospital. Technically, they can make that decision. They can be transported, or they can refuse transport and not go to the hospital. All right. In minors, they have consent obtained from a parent, legal guardian, or court-appointed custodian. So a minor is considered, in the United States, any individual under the age of 18. So consent should be obtained from a parent, legal guardian, or court-appointed custodian in any situation where the minor needs transport, treatment. However, an emancipated minor, emancipated minor is considered an adult, even though they're under the age of 18. An emancipated minor is an individual under the age of 18 who is married, pregnant, a parent, or a member of the armed forces, or financially independent and living away from home. If any of these can be proven, then the patient can make decisions on their own. They can make decisions for themselves. A competent adult may withdraw consent for any treatment at any time. However, a properly documented refusal must be had. So let's go back up and let's talk about the minors in reference to in loco parentis. This is the law that allows for teachers to refuse care or to request transport and treatment by EMS over students. So in the absence of the parent, teachers, or any type of caregiver, babysitters, and it's typically a contractual thing. It must be signed for that, hey, in the absence of me, if you can't get in touch with me, my babysitter so-and-so has the legal right to make medical decisions for my child in the situation where they need them. And definitely teachers. So your kid goes to school, teacher's teaching, blah, blah, blah. Kid has a seizure. Teacher calls a school nurse. The teacher or the school nurse or whoever the representative is in that organization has the legal right at that point to say, yeah, he needs to go to the hospital. Let's transport him. So in the absence of the parent, that's what in loco parentis means. All right, we'll move on. This is just an example of a refusal statement. So, refusal of service. So again, this is kind of a gray area. It happens a lot. It happens very nonchalantly, but people a lot of providers have not seen the repercussions of being sued. But a refusal of service is whenever a competent adult can refuse a service. However, the refusal of care must be informed and documented thoroughly. You should make multiple and sincere attempts to convince the patient to accept care if they need it, if it's needed. If they stub their toe, you go out there and say, yeah, your toe's not broken, you're fine. However, I would suggest that you get x-rays, you have a formal diagnosis from a physician or a mid-level provider, and we can facilitate that if you would like. However, if you want to stay here, that's up to you. So in that situation, you are still giving the patient a choice. You are advising them that if their vitals, and you don't have to say nothing bad's going to happen to you. However, you can paint the picture for them. Your blood pressure is normal. Everything is normal in reference to within normal limitations of vital signs. I don't feel any deformity. I don't feel any crepitus. I still feel a pulse below the site of injury. So we will be more than happy to take you to the hospital and for you to get x-rays. However, you can make that decision on your own. Don't talk them out of going, because witnesses on scene and the patient themselves, if they have it documented, if they're filming you, if they're recording you, which happens all the time, make sure that you document appropriately. Enlist the help of others, so family members or friends, to convince the patient to accept care whenever they need to. Make certain that the patient fully understands the implications of their decision. So if they refuse care, make sure that they understand, look, if I walk out, for example, I got called out to an elderly gentleman who kept passing out, put him on the monitor. He was in VTAC with a pulse at a very high rate, and he was refusing care. He was saying, boys, thank you. I don't want to go to the hospital. I don't want to put my wife through that. I had to explain to that gentleman, literally, whenever I take these electrodes off of you and I walk out this door, I'm going to sit in the parking lot and wait, because you will probably go into cardiac arrest. You will probably die by refusing treatment. You have to explain to the patient the risks of refusal, if there are risks. Consult with online medical direction. Let a physician talk to them. Call the ER and let an ER physician tell the patient, yes, I highly agree with this paramedic. If you do not go with him, you'll be dead in 10, 15 minutes. And also have witnesses, objective witnesses, sign release from liability forms. Advise the patient that he or she can call you again. Hey, we're 911. This is what we're here for. Don't feel bad about calling us. If you change your mind in 20 minutes, then call us. We'll be right back out here. And also, again, attempt to get the patient's family or friends to stay with the patient, just to keep an eye on them and make sure that intervention doesn't need to be had. And again, document the entire situation thoroughly in your patient care narrative. Do not just shortcut it. Still do a SOAP narrative, spot narrative, whatever you use, whatever type of narrative that you use. still document it appropriately. All right, so let's talk about some types of quote-unquote problem patients. So patients that can cause issues, and this is issues in reference to consent, that is. So violent patients, victim of a drug overdose, well, the patient experiencing a drug overdose, intoxicated adults or minors, ill or injured adults with no availability to provide consent for medical, injured minors with no adult available to provide consent. So in these situations, you have to treat appropriately, and you have to have witnesses. You have to document appropriately. If you have individuals who are on the borderline of being able to make decisions, you have to operate under the auspice of implied consent. Sometimes, however, that's document appropriately and have witnesses. Have law enforcement as a witness as well. All right. Obviously, in order to try to balance this, try to develop trust and rapport from the patient, and try to have a conversation with the patient. Try to sit down, let them understand that you are a human being too, and that you make decisions appropriately, and that you do feel like they need care at this time. However, if the patient is violent and they are experiencing a drug overdose that is inducing violence, so say excited delirium, at that point you will be operating under implied consent. You are saying, hey, if you were sober right now and you weren't punching through brick walls, you would want me to provide care for you. You would say, yeah, I want you to take me to the hospital and take care of me. So that is when you are also, the patient is a danger to themselves or others. So the patient is a danger to themselves by taking those drugs. They could run out in traffic and kill themselves, or they are a danger to somebody else. They're punching through walls. So what are they going to do to somebody's head? How do you know that they're not going to hurt somebody? Boundary issues. So professional boundaries, ethical and societal limitations to interactions between paramedics or healthcare personnel and patients they serve. So obviously, crossing professional boundaries can result in responsibilities. This can be breached by being too tired, unprepared, or seduced by patients, or trying to seduce patients. Either way, it doesn't matter. But just that is whenever you are led away from your principles, ethics, faith, allegiance, however you want to put it, it's dangerous. So avoid these areas. And obviously, this is a joke, being too tired. If you are assigned on the ambulance, if you're working for a combination department and you're assigned on the ambulance and the engine is quote unquote monitoring all the calls, they're at home or at the station in their nice little twin size beds, all comfy in their Crocs and just chilling while you're out running calls all night, you will be tired. You will be fatigued, and that is going to increase the likelihood of vehicle collisions, poor decision making, medication errors, things of that nature. But being unprepared can be prevented every time. Every time. Take the time, do the right thing, restock your truck, make sure everything is there. All right. So let's talk about some legal complications in reference to consent. Abandonment. So patient abandonment. This is the termination of the patient to paramedic relationship without providing for continuation of care while it was still needed and desired by the patient. So this can be a gray area sometimes. But if you physically leave a patient unattended for a short time, it may be grounds for a charge of abandonment. So you have to be very careful. And you have to, if you leave the patient, pretty much you need to get a refusal. And what I'm saying, when you leave the patient, if you say, all right, well, whatever, I'm going to, we're back in service. This is ridiculous. We don't need to be out here. Let's go, guys. And you throw your bag and you tell 911 or the radio, you say, hey, no patient found at this location, so on and so forth. If you made patient contact with that person, they can prove that you made contact with them. You tell radio, no patient contact, we're in service, and that patient truly needed medical care and there's a damage that results of your negligence, that is patient abandonment. Assault. We've already talked about this. This is unlawfully placing a person in apprehension of immediate bodily harm. So this is a patient, you are causing fear, you are threatening a person verbally that they will be hurt. Battery. Battery is actually physically touching another individual without his or her consent. And then false imprisonment. So this is taking the competent patient, the patient who says, look, I'm an adult. I can make medical decisions for my own. I am not going to the hospital with you. And you put them on the stretcher and transport them anyway. That is false imprisonment, which can result in civil or criminal liability. All right, we're still talking about some liabilities in reference to consent. Reasonable force. Reasonable force is the minimum amount of force necessary to ensure the patient does not cause injury to himself or anybody else. The use of excessive force can result in liability for a paramedic in the way of battery or damages that were caused. So if you have force used as punishment, that is assault and battery. So if you don't calm down, if you don't cooperate with me, I'm going to stick you with this needle, and then you stick them, that is excessive force. That is assault and battery. Also, if a patient is experiencing excited delirium, you tackle them to the ground, you're pushing their face into the dirt, you're putting your knee on their back, they can't breathe, and you are causing more damage than you are good and eventually killing the patient, possibly, that is excessive force as well. However, the use of chemical restraints in that situation would be great. Use ketamine, Versed, Haldol, whatever it requires in that situation to knock the patient down and cooperate, that's what you do. You don't physically harm them. However, in the situation to where you cannot justify those means, use of restraints may be indicated. Have police on scene with you, not only for protection. They have weapons that can protect you. They also are objective lenses. They can provide testimonies and statements saying, yes, paramedic so-and-so operated within the use of appropriate restraint. So again, local protocols, you could have straps, jackets, restraining blankets, but in every situation, use the least amount of force possible in order to safely control a patient while causing them the least discomfort. All right. Patient transportation, maintaining the same level of care that was initiated at the scene. So as far as operations of emergency vehicles, be familiar with state and local protocols. But again, during that patient transport, if you are riding lights and sirens, you still have to fully stop at every intersection. Don't roll the intersections, because that is equivalent to not stopping. So make sure that you stop, make eye contact with everybody, then keep driving. The patient's choice of destination and insurance company protocols. That is something that must be taken into account whenever the patient is requesting transport to a facility. Now, if you have protocols within your service that dictate that you are not allowed to transport to a facility that's outside of 30, 45 miles from anywhere within your jurisdiction, then that's how you protect yourself in that situation. However, if the patient requests to go to a hospital that's 15 minutes down the road versus 20 minutes down the road, and that's their choice. That is the option that they have. So make sure that you are treating the patient with respect there. The facility is based on the patient's request, the patient's need, and the facility's capability. So if the patient is a level 1 trauma and they want to go to a center where their doctor is, if they want to go to this other medical facility that's 20 minutes down the road, they're a level 1 trauma, However, the facility is not even a trauma center. They may be like a level 4, and they may not have any trauma designation. At that point, you cannot take that patient there, and you may have to have representatives of that hospital tell the patient that via phone. So, as we move on, let's talk about resuscitative issues. So this is classic DNRs or any type of legalities for like the PULSE, the physician orders for life-saving treatment, advanced directives, so on and so forth, things of that nature. That's what we're going to talk about here. All right. So moments when a DNR is not present, you are under obligation to begin resuscitative efforts. So if you find a patient, or if 911 is initiated by another party because of a patient who is unresponsive, pulseless, and apneic, you have a duty to act and you have a duty to treat until the moment of a true legal document, a do not resuscitate order, is put in front of you. However, if the patient is obviously dead, if there is obvious decomposition, or if there are injuries that are non-compatible with life, then it must be properly documented, properly communicated with medical direction, and then you do not provide care in that situation just as well. So let's talk about advanced directives. Advanced directives are documents created to ensure that a certain treatment choice is honored whenever a patient is unconscious or otherwise unable to express his or her choice of treatments. So this is there are several documents that are considered advanced directives. So things such as living wills, durable power of attorney. So a power of attorney is an individual who can make medical decisions for a patient in the absence of their express consent. So living wills, who designating power of attorneys, do not resuscitate orders, and organ donation cards. So these are all considered types of advanced directives. So a do not resuscitate order is an advanced directive. A living will is an advanced directive. So don't confuse the terms there. A living will is a legal document that allows a person or individual to specify the kinds of medical treatment he or she wishes to receive should the need arise. So this is saying, hey, if I'm incapacitated, I do want advanced life support procedures. I do want pain management, so on and so forth. Do not resuscitate orders. So this is in the event that the patient has died. The patient has gone into cardiac arrest and they are in need of resuscitation. It's a legal document that indicates to medical personnel which, if any, life-sustaining measures should be taken whenever a patient's heart and respiratory functions have ceased. So a living will would say, hey, if I'm dying, if I'm starting to go down the tube, I'm bradycardic, and I'm showing signs of shock, all I want is to be made comfortable. I want you to help me with my breathing. I want you to give me oxygen. I want you to still give me morphine so I'm not in any pain. The do not resuscitate order refers to once the patient has died. So once the patient has died, a DNR declares, I do not want to be resuscitated. Once I die, let me die. Valid DNRs should be honored. So if somebody puts a DNR in front of you in the situation, that is whenever you cease to give any life-sustaining measure. Now, as we move on, we'll talk about the PULSE, which again is that physician order for life-sustaining treatment. It is designed for terminally ill patients, so hospice patients typically. The terminally ill patient and the physician have an opportunity to consult on the patient's wishes and incorporate these ideas and these wishes into a set of specific orders as to the patient's care. It is signed by the physician, and it is to be honored by healthcare providers who deal with that patient during a medical crisis. All right. So not all states have adopted the idea of PULSE. However, you may, depending on where you work, you may run into this. Now, potential organ donation situations. It does save lives. These are things that that are starting to be utilized a lot more, and it's a consideration that's starting to be considered where you are transporting a corpse emergency to a hospital that will retrieve organs in this situation to where they can use the Vitalink in order to procure and transplant. But, however, consult online medical direction when you've identified a potential donor, and we will have lectures throughout the year, and we may have somebody come in from Northeast Georgia to discuss this process. So, field terminations or deaths that occur in the field. You must carefully and appropriately document this, because this is one of the biggest liabilities to your practice. Follow local and state protocols, and anytime this is done or this needs to be done, contact online medical direction for confirmation and guidance. It just backs you up. So as we move on, let's talk about crime and accident scenes or collision scenes. Obviously, do not sacrifice patient care to preserve evidence or to become involved in detective work. If you feel like this is a crime scene, or if this is an instance of human trafficking, or if something of that nature, immediately contact law enforcement tactfully in the situation where it can cause issues if they're not already involved. But protect yourself and other EMS personnel. That's number one, obviously. But do not move or touch anything unless it is necessary for patient care. If you still have a viable patient, if you have a patient who has been stabbed multiple times, they are still breathing, but they're unconscious, that is the moment where it's like, oh man, I don't want to really disturb any of this stuff, but I have to get to the patient, I have to treat them and transport them. But do your best to protect potential evidence. If you have shattered glass on the floor, if you have, I'm not trying to be gruesome, but OJ's gloves, if you find some blood-stained gloves on the floor, try not to move them, try not to touch them. Strictly extricate the patient from the environment carefully and treat them. If you need to remove items from the scene, be sure to document your actions and notify investigating officers. All right. In the same way you treat the scene of a motor vehicle collision where somebody has died or there were serious injuries involved, don't kick the bumper as you're walking up to the car. Like if the bumper has been separated from the vehicle, or if the motorcycle driver's helmet is 20 feet away from the deceased motorcycle driver, don't just kick the helmet or move it. Make sure that you treat that vehicle collision scene in the same way. Obviously, ensure your own safety. Make sure that it's lit up. If it's in the middle of the night, make it daytime with all the scene lights and everything. Treat patients as medically indicated. And also utilize the resources that are available, including additional personnel, including coroners, scene investigators, so on and so forth. Okay. So again, we've already brushed on the things that you have a duty. You are mandated to report. But this changes from state to state. But EMS personnel are required to report suspicious activity in reference to abuse of the elderly, human trafficking, abuse of children, also abuse to the homeless and invalid to proper authorities in an objective and timely manner. Again, when I say objective, I'm talking about non-accusatory. You can't say, well, the father is abusing the daughter. You can say, you can talk about the behaviors that you have seen. You talk about the injury patterns that are concurrent with that injury pattern, and then you report that. Again, you're not confronting anyone, and this is the situation where you have to be very, very tactful. If you can stay inside with the patient and distract the bystander or the suspected abuser, have your partner go outside and request PD intercept. That's probably the most tactful way of doing it. It's not necessary for you to prove abuse or neglect that it occurred before reporting, but it is necessary for you to provide and report your objective findings. Failure to report abuse or neglect is a bigger liability than reporting it. So whenever it comes to yourself and your professional well-being and your professional sustenance, this is it's a lot more risky to not report. Okay, let's move on down to employment laws. So, in reference to EMS employment laws or medical employment laws, there are different types of employment laws in reference to services. They address the employee and employer relationships, obviously, but volunteer agencies fall under the same jurisdiction of any of these laws, and typically they're going to be in reference to Title IX, Title VII's, and discriminatory and fair labor acts, but they can still be very complex. But anytime any breaches of the following things arises, then you can consult an attorney. All right. Americans with Disabilities Acts will prohibit the discrimination against qualified individuals with disabilities. So if you are qualified, you have all the qualifications that a paramedic should have, but you're colorblind. If you are still able to do your job, then they can't hold it against you that you're colorblind. Or if you have cochlear implants, if you are still able to perform the functions of a paramedic adequately and appropriately, then they cannot discriminate against you there. Title VII. So this is harassment and discrimination. Workplace harassment, that is. And that can be anything from just a hostile work environment, bullying, to sexual harassment. So let's talk about Title VII. Things that have been amended. So Equal Opportunity Employment Act. That was 1972. That is any of the age, race, gender, sexual preference, race, anything of that nature. An employer cannot discriminate against you. Age Discrimination and Employment Act of 1967. It doesn't matter the age of the individual unless it is a legal thing. You must be at least 18 years old to drive an ambulance. Outside of that, somebody cannot discriminate against you because you are in your 60s. If you are still fit, of sound mind and sound demeanor, and can perform the duties of a paramedic, they cannot discriminate against you. All right, Family and Medical Leave Act of 1993. So this is what FMLA is. A lot of people will utilize this in the situations of any type of not necessarily emergency, but any dire situation with their family. Let's say a loved one has a terminal illness to where they're going to be put into hospice care, or let's say somebody says, "Hey, you know what? I need help. I'm going to use EAP, which is the Employee Assistance Program. I have addiction to alcohol. I have an addiction to any type of substance. I'm going to utilize FMLA. I'm going to take a temporary leave of absence from work and go get help with that." So you cannot discriminate against an individual who is utilizing things of that nature. Also, FMLA can be utilized in maternal or paternal leave during the birth of a child. Fair Labor Standards Act of 1938. So this is what brings in minimum wage, overtime pay, record keeping, child labor standards, so on and so forth. These are the things that kind of, there's not necessarily a need for a union. These are laws. These are laws that everybody agrees upon to where it is ethical treatment of the American worker. Occupational Safety and Health Act. So this is the act that ensures that employers provide healthy and safe work environments and also provide the proper equipment, tools to protect themselves from occupational hazards, such as hard hats, such as respirators, such as eye protection, ear protection, things of that nature. And finally have the Ryan White CARE Act. It funds programs to improve the availability of health care for victims of AIDS and their families. That's it for Chapter 7. Go ahead and read and start Chapter 8.